Hi there, and welcome to the deep dive. This is where you send us the info and we sift through it all to pull out the key knowledge, those core ideas, and maybe some of those surprising bits that, really make things click. Today, it's just me, a bit of a solo mission. Our usual expert couldn't join today, but don't worry, I'll guide us through. We're diving into something pretty fascinating, though I admit it's quite intricate. Australian tax law. Specifically, we're looking at a Federal Court of Australia judgment. It's Merchant versus the Commissioner of Taxation, the 2025 full court decision, FCAFC 56. We're going right to the source material here, excerpts from the actual legal judgment. It's the best way to understand this pretty significant tax dispute. So, what's our mission today? Basically, to get our heads around the core issues in this case involving Mr. Gordon Stanley Merchant and, of course, the tax commissioner. We'll focus particularly on how the court interpreted Part IVA's, the Old 36 Act, that's the big anti-avoidance provision, and also the TOFA rules, the taxation of financial arrangements. Yeah, sounds technical, I know. But the aim here is clarity. We're looking for those key takeaways. Let's get started. Okay, first, let's just lay the groundwork. Bit of background on the case. The person at the center is Mr. Gordon Stanley Merchant. You might know the name started out as a surfer, making boards, then co-founded, a hugely successful board short business with his wife, Rena. Billabong. Right. The transactions that came under the microscope happened between 2014 and 2015. They involved selling shares in Billabong International BBG and another company, Plantic Technologies Ltd. And there was also some related debt forgiveness mixed in there. The Commissioner of Taxation took a very close look and made determinations under Part IVA, claiming tax benefits were obtained from the BBG share sale and the debt forgiveness. The Commissioner also had views on the TOFA rules, particularly regarding some future payment rights linked to the Plantic sale. Now, this wasn't the first stop. The case was initially heard in the federal court, and the primary judge actually dismissed Mr. Merchant's appeals. That was back in 2024. What we're digging into today is the appeal decision from the full court. So the next level up. Okay, let's get into the first major issue. The BBG share sales scheme and Section 177D of the 1936 Act. You can think of Section 177D as, well, the tax office's main tool against schemes set up primarily for tax avoidance. It focuses on whether a scheme was entered into for the dominant purpose. That's the key phrase, the dominant purpose of getting a tax benefit. So what was the commissioner's argument here? They said that when the Merchant Family Trust, the MFT, sold its Billabong shares to the Gordon Stanley Merchant Superannuation Fund, the GMSF, his super fund, essentially the main reason, the dominant purpose, was to crystallize a capital loss. Why? Well, the idea was that this loft could then be used to wipe out or reduce the capital gain they expected from selling the Plantic shares. Makes sense from a tax perspective, right? But Mr. Merchant, naturally, had a different story. His argument was, no, the sale was about freeing up cash in the family trust. And also, it was argued it was about getting potentially better investment returns for the super fund compared to just leaving cash in the bank. Plus, they wanted to keep control of those Billabong shares within the wider merchant group. Those were the stated commercial reasons. Right, this is where it gets really interesting. The full court looked at all the evidence, all the arguments, and they actually agreed with the primary judge. They concluded that the dominant purpose of that BBG share sale was, in fact, to obtain a tax benefit. What led them there? A few things. First, the timing. It was pretty significant. The sale happened just as the Plantic sale was looking very likely and critically when a trading window for BBG shares opened up. Coincidence? Maybe, but the court noted it. Second, and this is important, the sale was between related parties, the MFT and the GMSF. Mr. Merchant ultimately controlled both. So the shares didn't really leave his sphere of control. It wasn't like selling them on the open market to a stranger. The court also pointed to tax advice Mr. Merchant had received. This advice apparently suggested the BBG share sale was, let's say, desirable from a tax point of view, regardless of exactly how the Plantic sale transaction was structured. So the key takeaway here isn't just about whether tax was saved. It's about whether saving that tax was the main goal, the driving force, even if other reasons were put forward. And what about those other reasons? Freeing up cash, better investments. Well, the court wasn't really persuaded. They looked at the evidence and found there wasn't a clear, immediate need for cash in the MFT right when the shares were sold. And the investment argument, they questioned that too. Billabong hadn't paid dividends for a while, its share price was volatile. Calling it a better investment than cash was perhaps a stretch in the court's view. Plus, selling the shares actually meant Mr. Merchant's superfund had to temporarily stop paying his pension. That seemed counterintuitive if the goal was purely financial return for the fund. The commissioner also raised this idea of a wash sale, selling something to crystallize a loss, then effectively buying it back quickly. The court acknowledged the similarity but said selling to a related party where you don't actually give up control is different from a genuine market sale where you truly dispose of the asset. So wrapping up on Section 177D, the crucial thing is the objective assessment. The court looked at the whole scheme, its steps, its likely outcomes, and despite the reasons Mr. Merchant put forward, the court decided that, viewed objectively, the main driver was getting that capital loss for tax purposes. Okay. Let's shift gears now. Let's talk about the debt forgiveness schemes and Section 177E of the Act. This section is specifically aimed at schemes that are, and I quote, by way of or in the nature of dividend stripping or have substantially the same effect. What's dividend stripping? Basically, it's finding clever ways to get company profits out to shareholders without them having to pay the usual income tax on dividends. So the commissioner's argument here was this. Two companies related to Mr. Merge GSM Platy Ltd. And Tyrannery Platy Ltd. Had lent money to Plantic. When they forgave these loans, it made Plantic, the company being sold, more valuable. Its shares were worth more because it owed less money. The commissioner said this effectively transferred value, representing company profits, to Mr. Merchant as a shareholder of GSM and Tyranny in a way that avoided dividend tax. Right, now here, the full court actually diverged a bit from the primary judge. They didn't treat both debt forgiveness instances the same. This is quite nuanced. Let's take the Tyranny debt forgiveness first. It was about $4.2 million. On this one, the full court agreed with the primary judge. They found that forgiving this debt did have the substantial effect of dividend stripping under Section 177E. Why? Well, a key factor was that the amount forgiven, $4.215 million, represented pretty much all of Tyranny's retained earnings, almost its entire accumulated profit. And crucially, the way things worked out, the resulting increase in the capital gain within the MFT, because Plantic was now worth more, was completely soaked up by other capital losses, not the disallowed BBG loss. So the end result. A tax-free benefit landed with an associate of Mr. Merchant, derived from nearly all of Tyranny's profits. A key insight here, maybe for businesses listening, is how the scale of the transaction relative to the company's profits really matters, forgiving almost all retained earnings tax-free. That definitely caught the court's eye. Okay, but then there was the GSM debt forgiveness. This was a much larger, over $50 million. And here, the full court disagreed with the primary judge. They said this forgiveness did not have the substantial effect of dividend stripping. Why the difference? Again, scale and effect were key. That $50 million, while large, was actually less than 25% of GSM's total retained earnings. So proportionately, it wasn't stripping most of the profit. But even more importantly, look at the tax outcome. After the Part IVA adjustment disallowed the BBG loss, and after applying other legitimate capital losses, the remaining capital gain on the MFT, boosted by the debt forgiveness, ended up being taxable. It was taxable to GSM, the company, at the company tax rate of 30%. Now, the court pointed out something critical. This 30% company tax rate was actually higher than the effective tax rate Mr. Merchant would likely have paid if he'd received that same amount as a fully franked dividend back then. That would have been around 27.1%, thanks to imputation credits. So the effect wasn't avoiding tax on a substantial part of GSM's profits. If anything, the tax paid might have been slightly more than if it had been paid as a dividend. You see how the court really drills down into the actual financial and tax consequences. It wasn't just about form, it was about the substantive effect. So the main takeaway on Section 177E from this case is that the analysis is very specific. Each scheme, each transaction, is looked at on its own merits. Did it effectively convert taxable dividends into tax-free or significantly lower taxed benefits for the shareholder? That was the question. And the answer depended heavily on the specific numbers and tax outcomes in each situation. Right, nearly there. One last piece. The TOFA provisions taxation of financial arrangements. These rules basically dictate how you treat gains and losses from things like loans, derivatives, certain contracts, financial arrangements. The issue here revolved around the Plantic share sale agreement. It included rights to receive future payments called milestone amounts if Plantic hit certain targets after the sale. These targets weren't met, so the rights expired worthless. The question was, were these expired rights considered financial arrangements under TOFA? If yes, the MFT might have been able to claim a deduction, basically a loss on revenue account when they expired. But no, the full court agreed with the primary judge again on this point. They found that a specific exception in the TOFA rules applied. It's Section 230 under 60, subsection 13 of the 97 Act. What does this exception cover? It covers rights where the payment depends only on the economic performance of a business after it's been sold. Think future sales volumes, future profits, that kind of thing. The court looked at the milestone amounts and saw they were tied solely to Plantic hitting specific sales targets after Kurari bought it. Because the contingency was purely about this post-acquisition business performance, the rights fell squarely into that exception. Therefore, they weren't treated as financial arrangements under TOFA, and no deduction was available when they expired. So the learning here for deals involving earnouts or contingent payments is that if those future payments are genuinely and solely linked to the future economic success of the business being sold, they likely fall outside the main TOFA rules because of this specific exception. Just before we wrap up, it's worth mentioning something the court touched upon. They acknowledged this idea of potential unfairness, particularly arising from the primary judge's original decision where both Part Severe, disallowing the loss, and Section 177E, treating debt forgiveness like a dividend, seemed to apply, potentially leading to a harsh overall outcome. Now, the full court changing the decision on the GSM debt forgiveness under 177E probably lessened some of that perceived unfairness. There's also another section, 177F3, that gives the commissioner power to make compensatory adjustments to prevent excessive taxation when Part IVA applies. Now, the full court noted that neither side really pushed this point or explored it fully in the initial hearing, so it wasn't really decided here. Okay, let's try and summarize the key findings from the full court. 1. The BBG share sale from the trust to the superfund. The court confirmed its dominant purpose was obtaining a tax benefit. Section 177D applied, the capital loss was denied. 2. The Tiranui debt forgiveness. Yes, that had the substantial effect of dividend stripping. Section 177E applied. 3. The GSM debt forgiveness. No, the court overturned the initial finding. This did not have the substantial effect of dividend stripping under Section 177E, mainly due to the final tax outcome. 4. The expired milestone amounts from the Plantic sale. Not financial arrangements under TOFA due to the economic performance exception. No deduction. Phew. It's definitely complex stuff, isn't it? This case really underscores the detailed, objective analysis courts apply when they're looking at potential tax avoidance. It's not just about what you say you're doing, it's about the substance and effect. So, for you listening, hopefully this deep dive has highlighted just how crucial it is to understand the real purpose behind transactions and their actual effects, especially when tax is a major factor. Breaking down the court's reasoning on each part, the share sale, the debts, the TOFA rules, hopefully gave you some of those aha moments, clarifying how these complex rules interact. And as always, a final thought to leave you with. Think about how the principles discussed today, dominant purpose, the effect versus form in dividend stripping, contingent payments linked to performance, how might these apply in other contexts? Other business deals, asset sales between related parties, earnout arrangements. The principles are broader than just this one case. It's certainly food for thought. And if you're really keen, exploring Part AVA and TOFA further. Well, it's a challenging but fascinating area of Australian law. Thanks for joining me on this solo deep dive today.